Good afternoon, and welcome to the DC Bar Pro Bono Center's webinar, COVID-19 Liability Waivers for Small Businesses and Nonprofits. I'm Christine Kulumani, staff attorney with the DC Bar Pro Bono Center's nonprofit and small business legal assistance programs. I want to start out thanking my colleague Lauren Haley, who has done so much of the behind-the-scenes work to make today's webinar possible. Also, a tremendous thank you to Hunton and Andrew's Kurth for their support and partnership, particularly to our presenters, Kevin White, partner and co-chair of the firm's Labor and Employment Group, and Andrea Calem, senior attorney. Before we get started, I'd like to talk about some of the logistics for today's webinar. First, this webinar will be recorded. Additionally, you have access to the presentation slides in your GoToWebinar control panel under Handouts. If you have questions as we go along, please send them to us through the question box in the GoToWebinar control panel. We'll get to as many as we can during today's program. So what are we here for today? Well, over the past 6 months, life and business as usual has been drastically altered by COVID-19, starting with strict stay-at-home orders and many organizations temporarily closing their doors, to now moving through a gradual reopening of some activities and businesses with safety protocols in place. As businesses of all different types continue to open their doors to welcome clients and customers in person, a major concern is liability. Will the business be responsible if somebody contracts COVID-19 from them? How can the organization protect itself while still carrying out business and attempting to make ends meet? For many, liability waivers seem to be an attractive option. However, before making any decisions, it's important for small business owners and other decision makers to understand what liability waivers are, their limitations, and the actual risks faced when proper safety measures are in place. And with that, I hand it over to Kevin and Andrea. Thank you again.
Thank you for that introduction, and thank you everyone for joining us today. We are going to be going over liability waivers, which are a very timely topic, obviously, and one that is being debated among business owners and among politicians and policymakers. So we thought we would approach this in 3 ways. First, I will talk about some of the basics of waivers just to make sure we're all on the same page about the concepts. Then Andrea will talk about some of the specifics to DC, Maryland, and Virginia so that you're well grounded in what the current state of the law is in those jurisdictions. And then we'll conclude with some of the practical considerations and some of the other avenues that are available to help mitigate liability, mainly through immunity laws. So we'll be talking about those 3 areas during the course of the presentation, and welcome your questions throughout. Shortly after the pandemic started, our law firm started tracking the COVID-19 related lawsuits that were being filed around the country. And you can actually go to our website, and we have a map that you can, a tracking map that you can click on the various jurisdictions and see the kind of cases that are being filed. But what we wanted to know was, would COVID-19 lead to a lot of litigation? We expected that it would, and sure enough, it has. This information that we're showing you now is as of late last week, and thus far there have been more than 5,000 COVID-19 cases filed. Generally, 600 are employment-related type of cases, and of those, 93 relate to some lack of personal protective equipment, some kind of workplace exposure to COVID-19, personal injury claims related to COVID-19, and wrongful death claims related to COVID-19. So labor and employment cases, if you look by subject matter, I think are number 2 or number 3 on our list of the most popular types of claims that are being brought. In addition, there's also 20 personal injury cases relating to COVID-19 that relate to exposure to the virus in a public place. So again, you can go on our website and check out more specifics about the types. But the point is that consideration of a liability waiver is a legitimate consideration given the amount of litigation we're already seeing related to the pandemic. So let's talk a little bit about the basics. So what do we mean when we talk about a waiver? Very simply, a waiver means that the person who signs is abandoning a known legal claim or a known legal right. And when we put this in the context of business, we're talking about people signing away or agreeing to relinquish their right to sue the business for a personal injury. These are contracts entered into between the business and the consumer or employees if employees are involved, and they're governed by state law so that what works in one state doesn't necessarily work in all states. Many of you, I am sure, have encountered these before. They're very common for certain kinds of activities. If you go skiing, if you're brave enough to have ever gone skydiving, and if you have kids, you've undoubtedly signed waivers. If your kids play laser tag or go to some other birthday party at one of the bouncy houses or something along those lines, you will have encountered a liability waiver. And at the end of the day, again, you're just being asked to waive your rights in this particular context to personal injury claims arising out of COVID-19. So most states will enforce business waivers for this tort liability or personal injury liability, provided that the waiver meets certain very specific criteria. Number one, it has to be clear and unambiguous. You can't bury the liability waiver, and you can't use a bunch of legalese to hide its meaning from the person who's going to sign. It has to be specific as to what rights are being waived. As already mentioned, no legalese. Certain jurisdictions, a waiver such as this might be what's called against public policy, just meaning in that particular jurisdiction, these types of waivers are disfavored. And we'll talk about the state of the law in Virginia when it comes to the public policy. And then at the end of the day, these waivers, they generally protect companies against liability for negligence only. And that's probably the most important, I think, key for you to understand out of today's presentation, is that the liability waiver excuses negligence. It does not exclude intentional conduct, it doesn't exclude recklessness, and it doesn't exclude gross negligence. So again, if you happen to own a skydiving company, you can't put holes in all the parachutes, and because someone signed a liability waiver, escape liability for what happens to them. You still have to use all the care and act reasonably in your business. And in the case of COVID-19, what you'll see as we continue, that means you must comply with all of the requirements from the CDC and local health agencies about having a safe workplace and a safe business for consumers. So just to elaborate a little bit on what I just said, so negligence, that's failing to behave with the level of care that someone of ordinary prudence would have exercised in the same circumstances. And it can apply to both taking an action that is negligent, and it can also consist of omissions or failure or failing to act, which in the COVID-19 context, it's usually the failure to take some type of action, failure to provide the right type of equipment or the right safe environment is usually the type of claim that is raised. And at the end of the day, negligence is this, typically it was an accident. It wasn't intentionally done. There wasn't any gross negligence or recklessness with relation to what wasn't done or the action that was taken. So again, negligence is more along the lines of some type of accident. This is juxtaposed against intentional misconduct, which I think is easy for everyone to understand. Again, you own a skydiving company, you can't intentionally put holes in the parachutes before someone uses them and then rely on a waiver. That would be considered intentional misconduct. Reckless conduct and gross negligence kind of work hand in hand. Basically, it was clear what action should have been taken, and the business owner was extremely indifferent or disregarded that standard. So in the COVID-19 context, what we would be talking about is there are clear guidelines from the CDC and local health agencies about what you need to do to have, again, a safe workplace and a safe business environment. If you don't take any of those precautions or do any of the things that are required, a liability waiver isn't going to help you. That will most likely certainly be deemed to be reckless conduct or grossly negligent conduct, and the waiver would not apply to it. We're more in the realm of you are trying to comply, there was some accident or mistake that was made, and that's where the liability waiver could potentially come in and assist you. As I mentioned, there are these are contracts, and they're governed by state law. So typically there is no one size fits all liability waiver that would apply in all jurisdictions. Some states you will see will require more detail than others. Some require the waiver document to use specific words. It may actually require you to specifically refer to negligence. So you really have to know the law of each state in which you intend to use the business waiver to make sure that you have a legally compliant contract with the employee or the consumer, whoever you're having sign the liability waiver. And then one concept to just keep in the back of your mind is that many states interpret the waivers against the benefiting party. So in this case, if a business has a liability waiver and there's any ambiguity in it, any close call, if you will, and what the language means, most often in states, they will interpret it against the business owner and in favor of the consumer or the employee. So that's just something to keep in mind with drafting, and the importance of making sure you understand the law and the jurisdiction you're operating in, and that you have a very clear waiver, because it may be interpreted against you. So at this point, Andrea, I think I'll turn it over to you to talk a little bit about the specifics of the jurisdictions near us.
Thank you, Kevin. So going to our own DMV, there's a discrepancy in the way the states approach waivers. DC and Maryland are sort of on the same wavelength and approach it consistently. Both jurisdictions will enforce a waiver of liability for negligent conduct, but not intentional, reckless, or grossly negligent conduct. And this is consistent with the sort of the majority approach that businesses in some circumstances should be shielded from personal liability lawsuits or injury lawsuits based on a mistake or an accident. But the law doesn't want to incentivize businesses to be bad actors or to be overly careless because they're just not afraid of getting sued. So there's a number of cases that have grown up in each jurisdiction around the issue of waivers and what you need to show to make them enforceable. DC courts say that an enforceable liability waiver has to be spelled out with clarity. It has to clearly and unambiguously express an intent to release a party from liability for negligent conduct. And how do you do this? Courts have, in the course of issuing opinions, offered the following. One, the release can't be buried or hidden in a larger document. It has to be prominent and noticeable, either standing on its own or somehow demarcated in a larger document, bold print, a square around it, something of that nature. Two, while certain words with legal meanings have to be used, there's no need to make the waiver language overly complicated. As Kevin said earlier, you don't want legalese. It should be understandable to a person of average intelligence who is looking it over and deciding whether to sign it. Three, there's got to be a description of the type of injury that for which there will be no compensation, with a clear intent to release the company from liability for that kind of injury. So one thing a court will look at is whether the plaintiff's injuries were reasonably contemplated by the parties at the time the agreement was made. Maryland looks at these same factors and requires that the waiver clearly explain the potential harm that might result from this activity and a clear explanation that there will be no recourse for negligent conduct. But as you can see in the Maryland section, the courts there have set up a test which creates certain exceptions to enforceability even for negligence. A liability waiver, even for negligence, won't be upheld if there's excessively uneven bargaining power between the parties, or it's part of a transaction that affects the public interest. So what do those things mean? You can argue that most waivers are the result of unequal bargaining power, right? I mean, the idea is if you want our product or services, or if you want to attend this event, you sign away certain rights. So that could conceivably invalidate almost any waiver, but that's not what the courts in Maryland intend. The cases say they're concerned about really grossly unequal bargaining power when there are considerations of public importance or some kind of compelling need. Transactions that affect the public interest often involve regulated industries, some essential service like public transportation. So this really goes to the issue of whether people have a choice in patronizing the business or the event at issue. And it's very fact specific, or can be. Is this the only bank in town? Is there any other way to get your broken tooth fixed other than in a dentist's office? Is there more than one dentist in town? So it is true that sometimes it's hard to determine what kind of transaction involves the public interest. An example of this is in the case that's cited at the bottom of this slide, the Senior case. Sometimes it's easier to say what does not involve a public interest. And in that case, that was an injury at a health club. A woman went in for her initial assessment and she disclosed that she had serious lower back problems and that her general physical condition was poor. So she's put through her initial assessment where she goes and works on different machines, and the trainer put a 90-pound weight on an upper body weight machine and told her to lift it. And she said that when she did that, she felt a tearing or ripping sensation in her shoulder. And she told the trainer, who didn't do anything about it, just said, go on to the next machine. So this resulted in a lawsuit. And of course, this woman had signed a waiver, but she said, well, it's not enforceable because I had no bargaining power. And two, what's at issue here is health, the public's health, and that's a matter of great public interest. So is this of great public interest? This Maryland court said no. There's clearly unequal bargaining power with respect to the waiver, but it wasn't grossly out of proportion. Why? Because the plaintiff had a choice of other health clubs with other types of waivers, or she could have chosen not to train at a health club. She voluntarily applied for membership in this private organization and agreed to the terms. And although, better physical condition is the goal of joining a health club can't be compared to something that is essential to the state or its citizens, practical necessity to the public as a whole, like hospitals, schools, housing, or public utilities. So that's the majority view, and that gives you a little bit of an idea as to how you want to think about unequal bargaining power and what is involved in the public interest. So now we come to Virginia, which takes a different approach. The Virginia Supreme Court decided many years ago that it was not willing to enforce a release or waiver for personal injury caused by any future acts of negligence or any sort of misconduct that resulted in personal injury. Intentional, reckless, gross negligence, as well as negligence. The Virginia Supreme Court has said, no, this is against our state's public policy to do that. And it is one of only a handful of states with that rule. Two others are, interestingly, Montana and Louisiana. So liability waivers in Virginia for personal injury cannot be written the same way they are written in DC or Maryland. So is there any way to limit tort liability in Virginia? It can be done in some situations if it's clear that there's a risk associated with the activity and the person participating is fully aware of that risk. And that is called the assumption of the risk doctrine. And it's based on the principle that it's not fair for somebody who voluntarily exposes himself to a known danger to be allowed to recover for injuries that come from that danger. So there's a case listed at the bottom of the slide here. It's an auto racing case, and that was a circumstance in which the court found, no, everybody knows auto racing is dangerous and you have a risk of crashing and becoming seriously injured or dying if you engage in this activity, and you can't sue the owner of the raceway for your injuries. But if you contrast this to the first case on the slide, this is called Hyatt versus Lake Barcroft Community Association. In that case, a man was injured at a triathlon that started at Lake Barcroft. And what he did was wade into the water up to his thighs, and then he dove in and he hit his head on the bottom of the lake. The lake bottom was uneven. He'd signed a waiver, but the Virginia Supreme Court found it unenforceable. Now, in another state, this could have turned out differently. There are some inherent risks in a triathlon, especially when the swimming part is in a lake that's uneven and it's not a swimming pool with marked lanes and depths. But this is how Virginia looks at this issue. So how far does the assumption of the risk doctrine get you in Virginia? It's going to have limited utility, and here is why. When Virginia courts apply this doctrine, they want to be certain that the person who was harmed fully understood the nature and the extent of the risk involved in the activity, but that risk doesn't include the risk that conditions will be made more dangerous by someone else's negligent behavior. And the Mantanda case at the bottom, cited at the bottom of the slide, is a good example of how the assumption of the risk doctrine is limited in Virginia. The defendant in that case was a scuba diving business, and they taught the scuba diving lessons, a whole program, starting in a pool, doing several small dives in a lake, and then graduating to deeper dives. So in this case, a husband and a wife took these classes together, and everything went well up until the next to last dive of the program. The group came together for a 3-minute safety stop, and that's when someone noticed the wife of the couple was missing. She had somehow been separated from the group and was found at the bottom of the lake unresponsive, and she later died. And in the negligence lawsuit that followed, the defendant argued, well, she assumed the risk associated with diving. She signed a document saying she knew that among the risks were panicking in the water and drowning. But the court said no, what she didn't appreciate, what she could not have understood, is that she wouldn't be adequately supervised while she was learning. So the fact that her instructors lost track of her meant that they didn't exercise reasonable care. And she would have expected someone to come to her aid if she panicked. So this is the legal framework in DC, Maryland, and Virginia. And predicting how it will be applied to COVID-19 waivers is a little bit difficult at this point. We don't know, for instance, if a Maryland court in the health club case would have ruled differently if the plaintiff had caught COVID at the health club. Is that a matter of public health? Reasonable people might disagree about that. So it's a little bit of a guessing game at this point, but if you are planning on using a waiver, which can't hurt in most situations, we want you to know how to craft one that's likely to be enforceable. So in the next slides, I'm going to go over the elements that you'll need for an enforceable COVID-19 waiver. And as you might expect, they're different in Virginia than they are elsewhere. So first, as we discussed, is the title of the document. It has to be clear and call attention to its purpose. Courts are going to look at whether there's an attempt to hide it. The titles that are listed on this slide are all titles that we've seen on COVID-19 waivers. In Virginia, it's particularly important to include that assumption of the risk language, because that's the concept that you're targeting towards. All waivers generally will refer to assumption of the risk, but we highlight that you want to get that into the title, especially in Virginia. Now, as Kevin said earlier, waivers are contracts interpreted according to state law. So this language allows you to set up the contractual framework for the document. It recites that there's consideration for the waiver. Consideration is an exchange of something of value. And this consideration that in exchange for being allowed onto the premises or participating in an activity, a person will agree to the following terms and conditions. This part of the COVID-19 waiver is particularly important. Every waiver, a lawyer will tell you, explain the risks involved in the activity. With COVID-19, the risks are huge and applicable to everyone, and you want to clearly identify and explain them. This particular language we've seen used in many different COVID waivers, and it explains essentially that COVID is everywhere. It's a worldwide pandemic, it's very contagious, it can spread easily from person to person and by touching infected surfaces. And this is true of many illnesses, which in some legal contexts are referred to as ordinary diseases of life, like the flu, the common cold. So we want to place COVID in that context, something that's out there that everyone is exposed to if they go anywhere. This slide continues the explanation of the risk and clearly explains what the result might be, what might happen to you, and that's an important part of the waiver. In this case, you might become seriously ill, you might become disabled, you might die. Then there's language stating that the person acknowledges and understands this risk and has decided to go ahead with the activity anyway. I do it voluntarily, assuming full responsibility for it. This again is targeted to the assumption of the risk doctrine. Here, the goal of this language, which doesn't have to be used, but we recommend it in many, many situations. The goal of this language is to show that your business is not negligent. It's following all the recommended guidance from the Centers for Disease Control and the Occupational Health and Safety Administration, or OSHA, which is the agency which protects employee safety in the workplace. So this language can be very useful in setting expected standards of behavior from the people participating in the event or coming onto the premises. And of course, it should be factually accurate. As Kevin noted earlier, it doesn't matter if you have this language if you can't prove that you did these things, and doing those things is the best protection of all, as we will discuss a little later on. This language we've used in several waivers. It goes a step further and tries to shift some of the responsibility onto the person signing the waiver. And this is particularly apt in a COVID situation because a communicable disease is a community-based problem, right? That requires a community-based response. So you want the person signing the waiver to commit to being part of the solution and not just a passive bystander. They agree to comply with mask and distancing rules, rules about touching common surfaces or other people, using one-way travel paths, limiting the number of people in a room or in an elevator, all of which are set forth in CDC and OSHA guidelines. And people are going to do this for their own benefit as well as the benefit of others. They also here commit to removing themselves from a situation they believe is dangerous and notifying the owner or manager of the premises or the organizer of the event of any dangerous conditions. Now, we can't tell you that this language has been blessed by a court. This is all very new, but as an initial matter, as we're sort of launching into this era of COVID litigation, this kind of language makes sense to us. And we have seen it in quite a number of waivers. Some waivers go into even more detail on this point, such as listing COVID-19 symptoms, asking the individual to attest that they don't have those symptoms, and then to commit that they will notify someone if they do, so that contact tracing can take place. And whether or not you add this level of detail to your waiver depends on the context. Maybe it's a question of what kind of event this is, how frequently a person is visiting the premises or attending a function. At this time, of course, no court has ruled that this level of detail is required. We just don't know. Really, it's a judgment call, and that's part of what Kevin is going to be speaking to you about in the next section. This is the legal language. You know, you have to have some legal language, but it has to be fairly clear what you're trying to do. This is just one example. There are no magic words in DC or Maryland for the waiver, and you'll find release and indemnification language all over the internet on many different forms. You've probably got a form sitting on your desk or in your house that has some language like this. DC and Virginia and Maryland do not require any particular words like the use of the word negligence, but it has to be very clear that the form expresses the intention to waive the right to sue for the risks associated with COVID. It has to reference contagious illnesses, including influenza and COVID-19, at a minimum COVID-19. And this is a continuation of the release and waiver language. And here describes the, falls into line with the basic law on waivers, which is that they will apply to negligent conduct, but not conduct that is the result of gross negligence or recklessness or intentional misconduct of the company. Now, if you didn't have this limiting language, the waiver still might be enforceable. It would not be enforceable to protect against gross negligence or recklessness or intentional misconduct. It could be that a court would simply interpret it to say this only works as against negligent conduct. Here we go to Virginia. Virginia, you can't use that same waiver and release language. So what you do here is target the assumption of the risk doctrine. This language is designed to show that the person understands the risks and voluntarily assumes them and acknowledges that they have chosen to proceed based on that understanding. There's a personal interest and a personal benefit that they're getting out of this transaction. And this reflects the principles in the Virginia cases that we talked about earlier. Now, we have seen Virginia waivers that include the same traditional release language used in DC and Maryland. And sometimes this language is included with the hope or the understanding or the expectation that the court will uphold the portion of the waiver that is enforceable, the assumption of the risk part, but not the other part. So that could happen. That certainly could be the way the court deals with this type of document. There's some risk to that in Virginia because at least in some other contexts, the courts have held that they will not rewrite agreements, that agreements have to stand or fall on their own. Not sure if that would be applied to this particular kind of release, but it is something to keep in the back of your mind and consult with an attorney about. And many waivers, business waivers, contain a choice of law provision. It's not required, but it can be helpful because one jurisdiction's law may be more favorable than another's. So without having this provision, there are legal tests that will determine which state's law applies. And there's an analysis that takes place that considers things like where the contract was entered into, where it was negotiated, and what place has the most significant relationship to the transaction and the parties. But it's possible that such a clause would not be honored if it's just a patent attempt to escape the public policy of a state, for instance, like Virginia, that's unfavorable to these waivers where they wouldn't be enforced. So you have to think about that. And again, if you want to include a choice of law provision, consult legal counsel about the appropriate one if there's any doubt in your mind. And this is just the closing language, which is often in capital letters and bold print to show that the waiver was clear and the person understood what they were doing when they signed it. You should always have your company's name or letterhead or logo on the document, lines for the signature and the date, and always helpful to have a line for a printed name in case you can't read the signature and you need to figure out later on who actually signed your waivers. So this part has been about how to craft a COVID waiver. You can do it, but should you do it when it comes to COVID? And Kevin is going to take over now to discuss those issues.
And Kevin, before we move on, looking at some of this language and components of a liability waiver, we've had some really fantastic questions come up that I think are going to fit best here. So the sample Virginia language, it talks about children under somebody's care. How would making sure a minor is also covered by a liability waiver, how would a business or a nonprofit go about that? And would that vary based on jurisdiction?
Yeah, with minors, each state is a little different, and the purpose of the waiver also is taken into account. If you have a school event, for instance, it is understood that parents are going to be signing these waivers on behalf of minor children who are participating in the event. Most states will not enforce a waiver signed by a minor. And I think we can expect most courts to closely scrutinize in other than a school context, a waiver that somebody signs on behalf of a minor. That this Virginia language was taken from a school-related waiver. You don't always have to have the language in there about the minor, and probably it's a little more prudent not to have it for your average, event that adults attend or average store entrance or activity participation.
All right.
For COVID purposes, that is. As Kevin mentioned, if your kid goes and plays laser tag, you're signing that waiver on their behalf.
Absolutely. And so, school versus activity and different organizations and where they host things has changed a lot as a result of COVID-19. More activities are taking place outdoors, maybe yoga at the park, as opposed to inside of the yoga studio. Does the impact of an activity, does the impact of the location have anything to do, should a waiver change based on maybe whether it's happening in a business's office or the business goes to a customer's home or it's in a public space or a third party space, the public library, or holding an activity at a school or at a third party business?
Yes, the context, the location definitely matters, especially because you want to establish at the outset that you have exercised reasonable and ordinary care under the circumstances. And there are some places that you just do not have enough control over to be able to exercise that care. You can organize an outside event that, is remote, where there's distancing and people don't touch each other, but you're less in control of the environment than you are in a room in a building. So you want to take into account all of these factors and figure out, well, how much control do I have? What can I assure people that I'm doing, that this business is doing to protect them? And then what makes sense in terms of shifting the risk at that point? And that really goes to what Kevin's going to talk about is, should you do this? When is it appropriate? And what circumstances should you be thinking about?
All right, and one last question that falls kind of broadly into the category of the different sections. Should these liability waivers, if an organization decides it's the best fit for them, contain any type of stated length of time that it will be in effect? Or should customers or clients be signing one every time they come to the business or the organization, or would it last throughout the duration of the pandemic?
Yeah, that's again a hard question, an interesting question, a good one, a little bit hard to answer because it's very fact specific. Nobody wants to make a customer sign a waiver every time they walk into the door. This is a matter of practicalities. What really makes sense? Health clubs, for instance, when you sign your contract, you sign a waiver and you understand that it applies to every visit you make to the health club. So maybe that's one context in which a single waiver would apply. If it's a more infrequent kind of event or connection, you might want to have the waiver signed each time. You can certainly decide to put a time limit on it. If you have, say, one big event, a big convention, and you want to make it clear that you're limiting your risks associated with that event, you can tailor the waiver to that particular event, and it is time limited in that sense. There's no clear and hard, bright lines on this. A lot of it is a matter of common sense, what the market will bear, what your customers or employees or other people will agree to, and what makes the most sense from a business point of view. Kevin, anything that you wanted to add to that?
No, I think the only thing I would add on that last question was to keep in mind also that the COVID-19, our knowledge of COVID-19 and our response to it is pretty fluid. So we, as Andrea has said, the waiver needs to be specific, provide enough information to the consumer to make an intelligent decision. So if something we learn more about COVID-19 and there's something that has changed about the response to it, I would encourage you to revisit your waiver if you choose to use one to make sure it is matching up what we now know about COVID-19, especially if you use some of that additional language that Andrea talked about, such as listing out symptoms or protocols and procedures, those sorts of things. So that's what I would add, is just that the COVID-19 situation is fluid, so what goes in your document may need to change to keep up with what we're learning. Should we move on now to the last section of what we wanted to talk about? So the question becomes, is it worth it? You know the differences in the jurisdictions now and some of the challenges in Virginia. So the first thing to think about is this is using a liability waiver in the context of COVID-19. There's no body of precedent for us to point to say this is how you do it and we know it will be enforceable. So you could write the document and then find out later on that it, depending on the jurisdiction you're in, that it may not be enforceable. And there's some indication that it may be disfavored by the courts given the fact that we're dealing with a pandemic and some businesses are being encouraged to be open to cater to the consumers because it's an essential business. So a court may not look favorably upon that sort of almost as a quasi-public policy matter. At the end of the day, the liability waivers can be of limited utility because it doesn't excuse you from doing all of the things that you're supposed to do anyway. You have to take all the precautions that are required by OSHA, the CDC, local health agencies. And so what you're taking off the table really is the negligence component. If you make a mistake or there's an accident of some kind, that's really where the liability waiver might come in to be useful. And so like Andrea said, when we say it's of limited utility, that could be very powerful, but when you put that up against what the marketplace would expect or what your consumers would expect, it may not be as powerful as you think if it actually turns people off. People walk away from your business because they're concerned about it. And if you don't have a waiver and you do get sued under because of a COVID-related issue, the plaintiffs are probably going to have a difficult time showing causation anyway. It's difficult for them to show they caught COVID at your business. So that, again, the waiver could be helpful, but if it ends up harming your business, just keep in mind that the plaintiffs may have a difficult time making the claim anyway, so it may not be worth that risk to begin with. And then there are some public policy concerns, public health concerns that you have to be aware of. Of course, again, going back to the point, we'll keep reiterating, you still have to do all the things you're supposed to do. And then as we've been talking about, especially in response to the questions, the context matters for you about whether or not it's worth pursuing the waiver. So let's talk, there's different folks who you may want to have sign the waiver, and we can talk about some of the practical considerations for them. So the first bucket of folks we'll talk about are the consumers or customers and contractors. And we talked a little bit about this a minute ago. Is it actually practical to have every single person who comes onto the premises sign a document? And do they have to do that every time they come onto your premises? So another option might be to focus on this assumption of the risk doctrine that Andrea has been talking about. And instead of having people sign a document, instead you put up a sign that effectively tells people that there is a risk and that by entering the premises, they are assuming that risk. And we mentioned Georgia law here just because Georgia has taken the step of, in response to COVID-19, of actually making that the law. Business owners in Georgia can achieve basically what a limitation on liability or a liability waiver would give you by putting up one of these signs in their workplace or in their business. If you put up a sign like that or you hand someone a liability waiver, obviously that may cause customers or vendors to question the safety or sanitation of your facility. They may ask, why am I being asked to sign this if you're doing everything you're supposed to? You must be concerned that you're missing something or there's some risk that isn't obvious to me. You've probably read about these liability waivers in the press. They're a big policy debate, and you could wind up on the wrong side of publicity if you choose to have one and there is some sort of issue at your business. So again, it's more of a practical consideration and a business decision than it is a legal one, that it could lead to some bad publicity. Like I said, customers may consider that the waiver is a sign there's something wrong at the premises of the business. And if they do sue you, they may actually point to that waiver as evidence that there was a problem. Look, business owner, you knew that there was an issue and you tried to get me to sign this document to begin with to get you out of the harm you knew you were posing to consumers. And again, come back to the point we've been reiterating over and over again. No matter what you do, you're still going to have to follow all of the guidance that is issued by CDC, OSHA, the state OSHA equivalent, local health authorities. That's your best protection for sure, and you're going to have to do it anyway, even if you choose to use one of these liability waivers. We get a lot of questions here at the firm about whether or not we can have employees sign liability waivers. And I would just say, this is my personal experience only, that I would say that most clients, if they choose to do one, it's typically outward facing. It's the consumer or the customer or contractors or visitors to the facility who the business asked to sign one. I haven't seen a whole lot of employers try to have employees sign them. Usually once we start the discussion, they realize that that's going to be a real issue for employee morale if they're asked to sign a document like that, attempting to have them waive liability for a COVID exposure. And then employers also then realize, well, what do I do if someone refuses to sign? Am I going to fire that person? And what would the optics of that look like? Someone refused to give up their rights to a safe workplace and I fired them. That, while perfectly legitimate for a business to want to limit its liability exposure, the optics can just not be very good in the course of a lawsuit. Again, the best protection is following those guidelines, and the government has stepped in to try to help businesses who are following the guidelines. So there was an executive order that was issued back in May that directs federal agencies who are responsible for enforcement in this area to consider the good faith attempts to comply with the various requirements and regulations. And OSHA in particular has said that it will consider that employers' good faith efforts to comply with guidance. So again, your best protection is to follow the guidance and the regulations. Continue on with some of the things to think about if you're considering a liability waiver for employees. Employees can't waive their rights under OSHA, workers' comp, or the NLRA, which is the act that governs unions. You can't ask an employee on the front end to waive their rights under all of those various statutes. And that's a lot of where the COVID-19 type claims might arise. So it would be useless for you in that context anyway. Also, there's a presumption of work relatedness under workers' comp. So again, in many jurisdictions, so again, the waiver would be of limited help there. And in fact, it could actually be harmful in some workers' comp systems because that waiver could be used as evidence of a work-related exposure. And then finally, the employee, like I said, may actually use the waiver as evidence in any kind of lawsuit or action to show that the employer knew there was a risk and was trying to get employees to waive their rights through one of these waivers. So if you choose not to go the waiver route, or at least as you're deciding whether to use a waiver, there are some other things to keep in mind. And that is the immunity laws that are coming out now. If you followed this in the press, you've noticed that the latest stimulus package, one of the things that has held it up is on the Republican side, there's a strong preference for immunity waivers for businesses from COVID-19 claims, which the Democrats have been concerned about and haven't been willing to go as far as the Republicans. So under the federal law, really what this type of immunity is coming from is from the CARES Act. And we've listed here the ways in which it applies. So it applies to the manufacturers of respiratory protection devices. It also protects volunteer healthcare professionals from negligence type claims. But as the bullet point has said, that's a fairly limited federal immunity. And at least as last time I checked, it did not look like Congress was even close to coming up with an agreement on how there could be a national immunity for business owners for COVID-19 claims. So federal law is fairly limited, which means that the states have had to step in and try to fill the void, which means there is a patchwork of immunity laws, and those immunity laws differ from state to state, and they're ever changing. So we put this in here, number one, just so you understand that there are other ways you could be protected. And number two, to just make sure you're aware of this conversation that's going on, and so that you can monitor the situation to see if an immunity law would help you out in your business. But there are immunity laws for healthcare providers. Maryland has an existing law on the books that would apply in emergency situations. Virginia did it through an executive order. DC has a measure that has been enacted, but it still requires the mayor to take the next step and enact an order, which has not happened yet. So in our immediate area, there is some limited immunity for healthcare providers in Maryland and Virginia, and some potential for that to apply in DC if the mayor takes action. These are states not near us, but we just wanted to show you what those immunities could look like as this discussion unfolds, in case they are ever applicable in our area. But you can see that there can be limited immunity for essential businesses, which is what North Carolina has done. There can be limited immunity for COVID-19 exposure on premises generally, which is the way Utah went. There can be limited immunity to businesses that in good faith comply with the public health instructions, which is how Wyoming and Iowa have chosen to handle it. And then there could be immunity for businesses that follow the posting, like we talked about, which is the case in Georgia. Again, I'll kind of repeat what I've said many, many times now. Whether you choose to use a liability waiver or not, you're still going to have to comply with all of the requirements of federal, state, and local health officials. And we put here, if you don't have ready access or haven't checked those out yet, we put the links on here for you so that you know where to go to find out what it is you are supposed to do. So do those, and then hopefully we've given you enough information so that you can decide whether a liability waiver is right for you or not. But certainly we are available to answer any other questions you may have about liability waivers.
Great, thank you both so much. So we have had some more questions come in. We were talking about some of these various risks associated with waivers, and one of the ones that was mentioned both for customers and contractors and employees is that a waiver could be used to show that the business knew there was a risk and they wanted to protect themselves against being sued for that risk. What about, businesses have guidelines that they need to follow, both at the local level and the federal level. But if a business has a waiver that lays out the specific steps that they're taking, for example, We're following all CDC protocols, social distancing, staff are wearing masks, cleaning at X, Y, and Z frequency. And they don't actually take those steps, but have required folks to sign that waiver where the business says they're going to do that. Would that actually also be a situation where having a waiver poses, again, an additional risk to the business and opens them up to potentially more liability?
Yeah, so the question is, if they say they've taken all the right steps, but they actually have not, is that right?
Correct.
Yeah, I think number one, I think that dooms the liability waiver for more than one reason. And then I think also if it could open up to potentially more exposure for the business. I mean, that you could have someone claim they were fraudulently induced to do something, or they were misled into the situation, and they were injured in some way. They caught COVID-19 because of the bad information they were provided. So I think that would be a very bad decision to make. The waiver would certainly be unenforceable. And then if the person was harmed, I think it opens up the business owner to more liability.
Would it be all right for businesses that already have other types of liability waivers to add in a COVID-19 liability waiver alongside it and integrate the two documents going forward for the foreseeable future?
Andrea, do you want to take this one, or do you want me to take a crack at it?
There's no hard and fast rules on it. I'll just put in my 2 cents first, and then you can, maybe Kevin has additional thoughts. My feeling is that COVID is a fairly specific circumstance that you would want to address separately. You just would not want to add in "and COVID-19" into your standard waiver, because you'd want to clearly identify the risks of COVID. You could certainly roll it all into one if you had all of the elements, especially, the element explaining the COVID risk and what people are expected to do. But, hopefully the situation is not forever. It would, to me right now, it seems sensible to keep them apart, although it is by no means required. And maybe Kevin has different thoughts on that.
No, I agree completely. I would keep them separate for all the reasons you articulated, and then also for the reason that COVID-19 is not the typical risk someone would be thinking of when they sign the document. Again, if you go skydiving, you worry about certain risks. If you go to laser tag for your kids, you worry about a certain risk that are covered in the standard documents. But I think to have a clearly enforceable COVID-19 liability waiver, you need it to be standalone that addresses those risks in particular.
All right. So it looks like our hour is about up. Andrea or Kevin, do you have any final advice or comments or remarks before we wrap up?
Nothing from me. Thank you very much for having me.
Yeah, nothing here. I would just, if there's people on from Virginia, I would urge them to look at the Virginia OSH COVID standard. It's the first in the nation, and it imposes on Virginia businesses the obligation to conduct a hazard analysis in your workplace, and that's something everybody should be aware of. Other than that, I don't have anything, and hope this has been helpful to everybody, and thank you for being with us today.
Thank you, Andrea and Kevin, and thank you to all of our listeners for joining. We'll be sending out a survey to participants, so share your thoughts on this webinar there and any topics that you're interested in future webinars on. And remember that if you'd like to share this webinar with your fellow small business owners or nonprofit executives, this webinar was recorded, and you'll be able to find both the PowerPoint slides and a recording on our resource website, lawhelp.org/DC/CED, lawhelp.org/DC/CED. On this website, you can also find information about the Pro Bono Center's upcoming events and a wide variety of resources, including a link to sign up for a one-on-one brief advice consultation with an attorney if you have any follow-up questions about liability waivers or any other legal issues that your small business may be facing right now. Thanks again to Kevin and Andrea for taking time out of your packed schedules to share all of this information with us today, and to Hunton, Andrews, Kurth for partnering with us in general on this webinar.